Well, good morning. Thank you for joining us. We're just going to wait a couple of minutes for other people to join. So if you just hold on for a little while and we'll make a start. If you've just joined us, thank you, welcome. We're going to start in a moment. We're just waiting for a couple of other people to join. Okay, we're going to make a start then. So good morning, thanks for joining us. Well done for tearing yourself away from the US election. I've also had to pull myself away from that. That was very entertaining. I can't promise we're going to be as entertaining as that, but hopefully you're going to find this informative and interesting. I'm David Seals. I'm a partner at Down Solicitors in the employment team, and I'm joined by Nicola O'Dwyer today, who's also a partner in the employment team. We're going to be looking at redundancy. Clearly at the moment, with what's going on in society, this is a highly topical issue and a lot of redundancies are happening. And of course, because of the way the economy is, people are going to find it more difficult to find new employment. So of course, it makes it all the more important to get it right, because if you do get a claim, it could be a more expensive claim than would otherwise be the case in better times. So we're going to be looking at the procedure you should be going through today to mitigate the risks of tribunal claims. Now, if you've got any questions, there is a facility on here. If you've done other webinars, you're probably aware of this. There's a Q&A down the bottom there. And if you click on that, if you want to ask a question, and we'll have a look at those and try and answer them, depending on how the time goes. We're supposed to be finishing at 10:30, and we've got a lot to get through, so we'll crack on now. And I'm going to start by handing over to Nicola, who's going to cover some basics. And Nicola, I'm going to ask you, if employers want to make redundancies, is there somewhere they can go to, a Redundancy Act, where it sets down the procedure they have to follow?
Well, thank you, David. No, there's not actually a Redundancy Act which sets out the procedure. And you will be referring to the Employment Rights Act to find out what basically process you need to follow and what aspects that the tribunal would look at. So firstly, when you're looking at the Employment Rights Act and redundancy, so what are the reasons that you can fairly dismiss an employee? One of those is on the grounds of redundancy. So employees who have been employed for over 2 years have the right not to be unfairly dismissed. Therefore, you must follow a fair and reasonable redundancy process with those that you wish to make redundant. And so in effect, you need to be following the procedure that we will be talking about in this webinar. So for those employees that have less than 2 years employment with the company, can you reduce the redundancy process? So could you just make them redundant without following any consultation whatsoever? And the answer to that is yes, potentially you could do so. But if you have any potential concerns of discrimination or automatic unfair dismissal, then you should follow a thorough consultation procedure with them. So what is an automatic unfair dismissal, and what grounds could you bring, or the employee bring, such a claim? So you can bring a claim for automatic unfair dismissal from day one of an employee's employment. There are a number of grounds for the automatic unfair dismissal claim, which include whistleblowing, asserting a statutory right, and one which is particularly relevant at the moment, which is health and safety. So potentially an employee could come to you and say, well, due to the pandemic, I don't wish to currently come into the office because I'm concerned about catching COVID. Now, if the next day you subsequently make that person redundant, potentially they would have an argument that they have been automatically unfairly dismissed on the grounds of health and safety. So you just need to be careful there. The same applies to discrimination, in that, again, it is a day one right. And as many of you will know, there's 9 protected characteristics to bring a claim for unfair dismissal, such as sex, pregnancy, age, disability. So let's just put that into some sort of context. An employee could, again, approach you at work and say, I'm pregnant on one day, and the next, again, you say to her, right, I'm afraid that we've decided to make you redundant. Obviously, you've got less than 2 years employment with the company, and in effect, you don't need to follow a procedure. She may then try to bring a claim for discrimination at the employment tribunal on the basis that you have dismissed her because she told you she was pregnant and you were just simply using the reason of redundancy to dismiss her. So if you do have any potential concerns whatsoever for discrimination or automatic unfair dismissal, then I would certainly recommend that you follow a thorough consultation process. So what happens if the employee brings a claim at the employment tribunal? Well, then the burden of proof is on the employer to show that the reason for dismissal was redundancy, and that it was not connected to, for example, discrimination or even a personal animosity towards the employee. So to establish whether the dismissal was fair, the tribunal will consider a 2-part test. One, was there a potentially fair reason to dismiss, and whether the employer acted reasonably. So if the dismissal was found to be on the grounds of redundancy, then obviously that would be a fair reason for dismissal. However, can you show that you acted reasonably and that it was a genuine redundancy situation? So at the start of a redundancy process, or when the company is starting to think about the need to save costs maybe and potentially look at making redundancies, producing a written business case and identifying the need to make redundancies will assist with supporting your defence in that the redundancy was the main reason for a dismissal. The Tribunal will also consider various points when looking at whether you acted reasonably, and this includes considering whether the selection was fair, was there appropriate consultation, and was alternative employment considered. Obviously, hopefully you will have followed all the correct steps and you will be able to deal with these questions by the Employment Tribunal, and certainly this webinar will discuss those points. However, if the employee is successful in bringing a claim against the company, then the Tribunal can order that you make a payment to the employee. Now, that payment can consist of two elements. One's known as the basic award. So this is based on the same calculation as for a statutory redundancy payment. And the basic award would be reduced by any statutory redundancy payment made. And the second element is the compensatory award, which is the lowest of either a gross year's pay or the cap, which is currently £88,519. Now, if the employee is also bringing a claim for discrimination, any award is actually uncapped. So as you'll see on the slide, there's something identified as Polkey. Now, Polkey is a House of Lords case, which it was found that although a dismissal could be found that it was on the grounds of redundancy, it could be found that the procedural grounds or the consultation process was not actually followed correctly. And now a tribunal would look at, so they would find that the reason was redundancy, but on the basis that you didn't follow the correct consultation procedure, they may well just limit the compensation award to the amount of time that it would have taken you to follow a fair consultation procedure, and that may well be limited to 2 to 4 weeks. Now, collective consultation. So this is required if you're planning on making 20 or more employees redundant in a 90-day period. You're required to consult with the trade union or employee representatives and file a form HR1 with the Department of Business, Energy and Industrial Strategy. Now, if you're planning on making between 20 and 99 employees redundant, consultation must begin at least 30 days before the first dismissal and 45 days if you are planning on making 100 or more employees redundant. So now that we've looked at the basics, we should consider the procedure that you actually need to follow. Now, David, could you tell me how you actually go about choosing which employees will go into the selection pool?
Thanks, Nicola. This is absolutely key. So this is at the start of the procedure, really. This is the first thing you're going to be looking at. What's the pool? What's the group of employees from whom I'm going to select redundancies? And it's so important for employers to get this right, because if you get it wrong, then you're immediately on the back foot and you've got problems that you probably can't sort out later in the process. There's other parts of redundancy, like consultation, that if you don't get quite right, you might be able to remedy that later, for instance, on an appeal. But if you get your selection group wrong in the first place, then really it's difficult to get that back on track. So how you do the selection group is going to depend entirely on the circumstances of your case. For example, let's say you're a logistics business, you've got a couple of warehouses in Croydon and Reading. You've got 10 drivers and you've decided you can do without 10 drivers. You could manage on 8. So what's your selection pool? Is it just the drivers at both sites? Is it just the drivers at Croydon or at Reading? Let's say at Croydon, that's where you want to make the redundancies. And in the warehouse there, what happens is the drivers spend, say, 20% of their time also picking and packing goods. So they're not spending all their time driving. And you've got people who are employed at the warehouse doing the picking and packing, but they just do that. But they can also drive. You don't use them for driving, but they could drive. So what's your selection pool then? Is it the Croydon drivers, or is it the Croydon drivers and the warehouse people doing the picking and packing? This is a difficult issue for employers to work out. Now, clearly, employers want to try generally to keep the selection pool down as small as possible, so it's less disruptive. You're causing less worry within the workforce, but that may mean that it's not a fair process. So let's have a look at some of the case law decisions, because they're instructive in terms of giving us an idea of how tribunals will approach this. And so there's a few cases there on the slide. I just want to talk about those. So the first one, Wrexham Golf Club and Ingham. Now, I don't think this one's going to give us too much difficulty, but what happened here is Mr. Ingham was a bar steward and he managed the bar. There were other bar staff, but he had a role that was quite distinct. Nobody else did the same job as him. And when the golf club wanted to reduce costs, they decided to have a redundancy process that involved just him. They consulted with him and they dismissed him for redundancy. And he brought a claim, and the Employment Tribunal decided that he had been unfairly dismissed because the employer had failed in that case to explore a wider selection pool, i.e. that they were wrong just to focus on Mr. Ingham. The employer in that case appealed, and the Employment Appeal Tribunal criticised the tribunal's decision. It said that it didn't make sense what the tribunal was saying. It hadn't articulated why it was that confining the selection pool to one in this particular case was wrong, and that in effect the employer had been quite able to do that because Mr. Ingham had a role that was different to other employees. If we move on to Hendy Banks and Fairbrother, this is a case involving a manufacturer. And Mr. Fairbrother was one of a few very experienced employees in the finishing department who were trained to use something called a binding machine. And those employees spent about a third of their time on this binding machine. And then the majority of their time they spent doing general finishing work. And what the employer did when it carried out a redundancy selection process is it confined the selection group just to Mr. Fairbrother and those that could use the binding machine. He brought a claim with the Employment Tribunal for unfair dismissal, and he succeeded. And the employer's appeal against that finding of unfair dismissal failed. And the Employment Appeal Tribunal said that no reasonable employer in those circumstances would have confined the selection pool just to those workers that were working on the binding machine, and that a reasonable selection pool would have been the whole finishing department. So those two cases I don't think give us too much trouble. The next two are a bit more tricky. So first of all, let's have a look at Capita and Bayard. Now, this is a case involving actuaries who were managing assets belonging to pension funds. So Ms. Bayard was one of 4 actuaries working for Capita. And apparently actuaries are personal appointments, although they can be changed. Okay, but the employer in this case took the view that it didn't want to opened this selection pool out to all 4 actuaries. What had happened is that Miss Bayard, not for any fault of hers, was losing clients to the point where she didn't have enough work to do. So when that happened, the employer decided to make her redundant, but as I said, it didn't look at the other 3 actuaries who did the same work but had different clients. And she brought a claim, and the Employment Tribunal found that that dismissal was unfair because that selection pool confined just to her was an unfair one. It listened to the employer's argument that it wouldn't be right to have the pool to be wider to include all 4, because that would mean that potentially clients would have to move to a different actuary. And this could mean that they could lose clients. The tribunal found that the risk of that on the facts of the case was low, and therefore that wasn't a good reason to confine the selection pool as it had. And the employer's appeal failed in that case. So compare that now to Albus, Vickers and Lloyd, and on the face of it, this is a similar kind of situation, but with a different result, which doesn't help us really. So in Albus, Vickers and Lloyd, Mr. Lloyd is an export manager, and he's one of 8 other, so a pool of 9. So one of 9 export managers, all working in the UK, but doing the same work but with different territories. So his territory was Greece, Cyprus and Portugal, and it turns out this was an unprofitable territory. So the employer wanted to discontinue acting in that territory. And what it did was it had a selection pool which was just confined to him. It didn't look at the other 8 export managers, even though, as I say, they worked in the UK and they've all got different territories which were overseas, but they just combined it to him. Anyway, he brought a claim for unfair dismissal, and he succeeded. But the odd thing about the case is the tribunal found that the selection group confined just to him was fine. That was okay, that the tribunal, that the employer had acted reasonably in having just him in the selection pool. But it found the dismissal unfair for other reasons, including the fact that they hadn't invited volunteers. And it awarded £55,000 in compensation to Mr. Lloyd. Now, what happened next was the employer appealed against that decision, and the Employment Appeal Tribunal ruled that the appeal should succeed in part. Basically, what they found was that although the tribunal had confined the selection group to 1, it should have, and therefore, and that it found that that was okay. It should have gone on to find that even setting aside the voluntary redundancy point, it would have been inevitable that he would have been dismissed. I.e., if he's in a selection pool of 1, it shouldn't have mattered what followed. He should have got either much lower compensation than that or no compensation. Now, what Mr. Lloyd didn't do is he didn't cross appeal on the selection pool point. He should have said, well, I'm also going to appeal on the basis that that selection group confined to me wasn't fair. But he didn't cross appeal. So the Employment Appeal Tribunal didn't look at that point. So there we have a decision of a tribunal saying that a selection pool of 1 where you have these 9 export managers based in the UK was okay. So that tends to contrast badly with the Capita decision. So that's not very helpful. Now, what about where you have different sites or different business units? And commonly, of course, this happens. Now, that could be relevant, and it was in the case of Highland Fish Farmers and Thorburn. Here, Mr. Thorburn worked at one of the sites of this company they had multiple sites and they decided to close one, which was the one that Mr. Thorburn worked at. But he had worked at other sites of the company, and he said he was quite happy to go back and work at another site. But the employer didn't want to widen this out beyond the site that it was closing. So it just confined the redundancies to workers at that site that was closing. And the Employment Tribunal held that it was unfair for it to do that. It should have looked at workers from the other sites to have a fair selection pool. What about different business units? And of course, employers will organize themselves in different ways, and they may have different departments, different business units, and so on. And that's an internal organization thing. And that might then dictate how they go about forming the selection group, but take care there. So in this case of Caverno and Parker, what you had was an employer that had organized and set up two separate business units. One of them carried out maintenance work and the other mainly construction work. And over time, though, this changed so that the construction workers also started to do mainly maintenance work. When this employer had to carry out redundancy selection exercise, it confined the selection pool just to the business unit that had all along been doing the maintenance work, and ignoring the other business unit that had changed its work, so it was also doing maintenance work. And the tribunal found that was unfair. That this was an artificial divide here, using the different business units as the excuse for confining the selection pool to one group of workers. What the employer should have been doing there is looking at what people were doing, what kind of work they were doing, and it become the case here that even though they were different business units, they were doing the same kind of work. So a reasonable selection pool would have included both business units. So that was an unfair dismissal as well. Okay, so that's the selection group. Nicola, once you've decided what your selection group is, how do you then go and decide who's going to be selected for redundancy in that group?
Thank you, David. So we would look at some selection criteria, which you would score the employees against. Again, you need to be showing that you're acting reasonably. So the selection criteria that you choose should be as objective as possible and capable of being verified independently, such as any documents you may have on the employee's personnel file. You should also avoid using any discriminatory criteria, such as last in, first out, as that can be considered to be discriminatory on the grounds of age. Also, a decision based mainly on attendance records could be considered to be discriminatory if you have included somebody's attendance records because of a disability, and so they have low, so they would score low on that. And also if a female employee, for example, has a lot of time off due to pregnancy, and also obviously the maternity leave. Now, interestingly, a solicitor's firm, Eversheds, decided that they would give an inflated score to a female employee who was off on maternity leave when they went through the scoring criteria. And they thought, obviously, that that would be the best thing to do, and they would be safe. However, a male employee brought a claim for discrimination, for less favourable treatment, and he was successful in that claim. So you need to be aware that you need to treat everybody fairly. Obviously, the case doesn't actually rule out using attendance records as part of the criteria. But as I said, you must consider it carefully and also disregard any period of absence relating to pregnancy or disability. So apart from attendance, potentially fair selection criteria may include performance and ability, skills, experience, as you can see on the slide, flexibility, future potential, disciplinary records, length of service. Obviously, with the length of service, it can't be the only criteria. As I've discussed previously, you can't use the last in, first out rule. So these types of criteria should be able to be scored by reference to company records, which would be in the personnel file. So such as appraisals, obviously you would have sickness data, again, attendance data on the personnel file. So scoring criteria is then best placed in a matrix, which would then set out the scores, the criteria that you're using, and whether or not the company has actually placed any additional weighting on one criteria over another. Now, there's the potential that you may consider performance is a much more important criteria than, say, for example, attendance, and therefore you may weight that higher within the matrix. Now, if you do that, and again with the criteria that you use, you must be able to justify that and any of the scoring should an employee decide to question you on it. So now once you've set up the scoring criteria, you've got it in a matrix, the scoring should be carried out by 2 managers. And this is to avoid any claim that the manager was biased towards a particular employee or potentially held any animosity towards them. Now, there are a number of cases that have been heard within the Employment Tribunal which have addressed selection criteria. So I'm just going to go through some of them with you. So in the case of Graham and ABF, the Tribunal considered that attitude as a selection criteria was dangerously ambiguous and vague. I mean, they did also comment that it may be appropriate in some cases for an employer to be able to use it, but they must be able to justify the reason for that. You've then got the case of KGB, Micros Limited and Lewis, and the Tribunal found that cost savings as a comparison with who cost most in terms of overheads and generated the least revenue was not acceptable. In the case of Williams and Compare Maxim, employees who, in the opinion of the managers concerned, would keep the company viable was again not an acceptable criteria. However, in contrast, you've got the case of Howard and Siemens Energy Services, where the criteria of company values was accepted by the Tribunal, although they did accept that it is arguably subjective. Again, it emphasised that criteria must be applied in an objective and transparent way. In Gannison, they looked at employee trajectory and future potential, and again the tribunal found that these were acceptable criteria. Now the employer, Mental Health UK, decided that they would follow a completely different route and not use selection criteria in the way that I've just explained, but went through a series of competency tests, which were normally used as a recruitment exercise. So these were scored by HR, the HR department, and did not involve the actual managers of the employee, and nor did it take into account any of the appraisals. And the Employment Appeal Tribunal found that this approach was unfair. So I think this case of Mental Health UK shows the importance of having the managers involved to do the scoring. And as I said previously, being able to have documentation which can provide you with reasons as to why you gave a particular employee those scores. So David, now that we've carried out the scoring, how do you actually consult with those employees?
Thanks, Nicola. Well, the first question on the consultation is, who are you going to be consulting with? And you've just done your scoring. So let's say you had a group of 10 and you found that of the 10, you say you want to lose 2 staff and you've scored 2 the lowest. So who are you consulting with? The whole group of 10 still, or just the 2 that you've scored the lowest? Well, there's a divergence of opinion on that. It will depend a little on how risk averse you are. Certainly a cautious approach would be to consult everyone in the group. Although I think that could end up being a bit artificial, because for instance, if you're meeting with people who've basically been not scored low and who haven't therefore been selected provisionally for redundancy, then there's not really a lot to talk about, is there? Because in effect, they're safe. So what a lot of people will do is just consult with those staff who've been selected as at risk, i.e. they've scored the lowest and they've been chosen. Now, the other thing, of course, is by involving a wider group, you're worrying people, aren't you? And you may be causing them to be nervous and start looking for other jobs. And of course, these are your people that you've scored higher, your better people, by virtue of the scoring. So do you want to worry them? So a lot of times employers will just consult with the staff who've actually been scored the lowest and have been selected. But that's something that needs to be considered. Okay, so once you've decided who you're consulting with, what do you need to cover? Well, as I think Nicola said earlier, the 3 main things are probably going to be the selection process itself, the group, how you've then scored the group, and then if there's any alternatives to redundancy, and we'll come on to the alternatives in a minute. But it may be uncontentious, the selection group, or it might not. I mean, we talked about it at the beginning, but if you've confined it down to a small group, especially if you've got a pool of 1, then that's likely to be contentious, and you're probably going to have to discuss that in the consultation process, or you may get a claim later if that hasn't been dealt with. If you do discuss it in the consultation process, then you've got a chance to put your case to the employee as to why you've done it that way, and hopefully reassure them that it was fair. The next thing you're going to have to discuss is probably the scoring, assuming this is not a pool of 1 and that you've you've got a group and you've scored them, and they've scored low. Now, do you have to show them the scores? You do, really, yes. I've come across employers that have tried to get away with not showing employees the scores, but that's really a non-starter, I think. And certainly the case law indicates that they've got to at least be given their own scores. Otherwise, how can you have a sensible conversation about, how can you consult with them about it? How can they challenge what you've done in the scoring unless you show them the scores? So I think that's pretty clear. Do you have to show them the scores for the wider group? Yes, I think you probably should do, although you'll need to anonymize the scores for data protection issues. But I think what you should do is give them a table with all the scores, and they can see where they've come, and then they can have a full discussion about the scoring. And that may be uncomfortable, but that's not the point. The point is that if you're going to do a fair dismissal, then you've got to consult with them properly, and this means giving them the opportunity to challenge what you've done. Now, what about the timing of all this? How long does a consultation process have to go on for? Now, Nicola mentioned some timings where you've got collective consultation and a large-scale redundancy, but those don't apply to individual consultation. There's in fact no prescribed rules on how long it should take. It just needs to be reasonable in all the circumstances. So it will vary, but what we normally find is something like 2 to 4 weeks. And you'd expect at least 2 consultation meetings. Rarely one. Rarely will one consultation meeting be fair. Possibly it could be if it was a really straightforward case, you know, the closure of a business, for instance, then, you know, there's not a lot to discuss. But in most cases, you'll find at least 2 meetings, maybe more. It really depends how involved it is, how contentious it is, the selection issues and so on. You could end up with 4 meetings. Now, what about right to be accompanied? There isn't actually a right to be accompanied individual consultation meetings in the way that you have that right if it's a disciplinary or a grievance case. In those cases, it's actually a statutory right to be accompanied by a trade union rep or work colleague to one of those meetings. That's not the case where redundancy is involved. There is no legal right, but it is certainly, for a lot of companies, good HR practice to allow it. If that right is allowed, then it might be confined to work colleagues rather than allowing trade union reps if workers have trade union representation. Anyone who's been in a meeting where there was a trade union rep may have found that can be challenging. So alternative employment, that's a key thing that you're going to need to look at as part of the consultation. But what is the extent of the employer's obligation there? Well, it's possibly more limited than you think. First of all, I should just point out a very important statutory rule that this concerns people returning from maternity leave or adoption leave, whereby if there are any suitable vacancies, those people have to be given priority for those roles, regardless of whether or not they're the best candidate. That doesn't matter, they get automatic priority under statute. Some see that as an unusual rule, but it's been on the statute for a long time. It's never been changed. Now, that aside, employers have got a fair degree of flexibility. So, for example, I mean, of course, you should be looking at, are there any vacancies for people? But a lot of companies will just point to their intranet site and say, there you go, you find a vacancy, you can apply for it. They're probably all right to do that. I'm certainly not aware of any case law that has held that would be unfair to take that kind of approach. And it's probably also the case that an employer, even though it has a vacancy, could potentially appoint an external candidate to that vacancy where it has at risk of redundancy employees who are otherwise going to be dismissed if they're not given that vacancy. They probably can do that. I'm not aware of any case law on it, but I've certainly seen that happen a lot in practice. So it seems the employer probably has got a fair degree of leeway there to choose the best candidate, not necessarily automatically appoint someone just because they're at risk of redundancy. What about companies where you have a group structure? Do you have to offer vacancies in other group companies? That depends, is the answer. Potentially, yes, you might have to, but it will depend a bit on the circumstances. There has been case law where people haven't been offered vacancies in group companies, and that was held to be an unfair dismissal. But it won't always be the case. But certainly what you can't do is rely on the fact that your company is a distinct legal entity, and therefore you don't have to look at other companies that are associated with it. That won't necessarily work. I think the key thing is what's happened in the past. If someone could demonstrate that there is transferability between employees working in the group companies, i.e. it's happened before, then if you don't do that on a redundancy, you're clearly going to be in a tricky situation. It could be quite different if the way that the group is set up, that there is no transferability, and it's never happened. I think there an employee could find it more difficult to say that they should have been offered a vacancy that arose in a group company. So it will depend a bit on the circumstances, that one. Now we'll deal with bumping. We can't have a redundancy webinar without talking about bumping, but some people won't know what it is. So let me just explain very briefly. Bumping is where A's role is redundant, but you don't dismiss A. What you do is you dismiss B and you give A B's role. Okay, so that's bumping. Now, this is generally pretty unpopular with everybody for reasons that won't surprise you. But be careful, because it has been held in some cases that the failure to consider it would result in an unfair dismissal. And there's a couple of cases here. We'll just look at these briefly. The first one, I don't think will give us too much trouble, but the second one's a bit more contentious. So Thomas and Betts is an old case, but there you had somebody who was a very established employee, I think quite a sort of low-level role. But anyway, the company had recently hired a new person doing packing, and they dismissed the other employee, the one who'd been there a long time, and they claimed unfair dismissal. And the tribunal found that the dismissal was unfair because the employer should have considered dismissing the recently appointed packer and giving that work to the person that was made redundant. So it was unfair dismissal. So that's that case, Thomas and Betts. But Lionel, Leventhal and North is a lot more contentious. There, Mr. North worked for a publishing house, and he was a senior editor there. And he was dismissed for redundancy, and he brought an unfair dismissal claim, and he succeeded. And one of the grounds that the tribunal found he succeeded on was the fact that the employer had not considered dismissing a more junior editor and giving Mr. North that role to him. That's a lot more difficult to take, that one. Now, it's not as bad as all that, because although they found it was an unfair dismissal, the appeal tribunal did refer it back to the tribunal to say, well, look, we think it was an unfair dismissal because they didn't consider bumping, but we'll let you decide what the compensation is going to be. In other words, the tribunal had to decide, Mr. North, even if he had been invited to take the junior role, would he have actually taken it? So that's bumping. So just be wary of it. Sometimes it's relevant that you have to look at it. I notice we've got 10 minutes left, so moving on here. The furlough scheme, of course, is unique, and it's given us a novel issue in redundancy cases, in that people are going to potentially come forward and say, well, look, you could have held off making me redundant by furloughing me. And of course, we've seen that extended in recent days, the furlough scheme, now to the start of December. Who knows, maybe it'll go on for longer. And then the job support scheme will kick in after that, we believe, but we'll have to see. What if you don't furlough someone when they've asked to be furloughed, and you make them redundant instead? Could they have a case? The answer is we don't know. It's going to depend, I think, on the circumstances of the particular case. Certainly, I've dealt with cases in recent months where the employer was in a situation where the employee was saying, please furlough me, don't make me redundant. But really, the outlook in those cases was that this was not going to be a short-term thing, that even at the end of the furlough scheme, then, I mean, it was looking to end at the end of October. But looking, I think we were in sort of June time, but we really didn't think things were going to bounce back sufficiently that it would have made any difference. So that was one where we rejected it. It could be different, though, in a case where it looks on the facts of the case like there could be a bounce back. And so this sort of short-term furlough arrangement could be a way of preserving a job for a few months until such time as the business bounces back. In that kind of case, I think an employee would have a stronger case for saying, well, dismissal was unfair because you didn't furlough me, but it's going to depend. So that's alternatives to employment. Nicola, if I could hand over to you, you've decided you're going to make people redundant. So what do you do to tell them that?
Thank you, David. So you need to inform them in writing of the fact that they are to be made redundant and the business reasons for that. So in their redundancy notice, which is their final letter confirming their dismissal, you should obviously address the employee's notice period, whether they will be paid in lieu of notice, whether they'll be placed on garden leave, or if they are required to work their notice period. Now, if they are required to work their notice period, you should make them aware that they can have reasonable time off to find alternative employment. Also in the letter, you'll address any outstanding holiday pay, or on the flip side, whether any money is due to the company. And of course, the most important thing normally for the employee, which is how much redundancy pay will they get. So at the moment, the maximum statutory redundancy pay is £16,140. And the redundancy pay is based on the employee's age, length of service, and weekly pay. Now, there's a cap on the weekly pay, which is currently £538. So you should identify in the final letter, the redundancy notice, the calculation for the statutory redundancy pay. Now, as I'm sure you're all aware, any payments of salary, notice or holiday will obviously be subject to tax and national insurance, but statutory redundancy payment is tax-free. Obviously, if you offer the employee an enhanced redundancy payment, then anything over £30,000 will be taxable. And also, if you are offering an enhanced redundancy payment, you may well wish to offer a settlement agreement to the employee so that it's in full and final settlement and they are not able to bring any further claim against the company. If you're just paying a statutory redundancy payment, then it's very unlikely that an employee would sign a settlement agreement, because it's they're just getting paid what they are due anyway. Potentially the other scenario you may use a settlement agreement would be in a voluntary redundancy situation, but it's not always necessary and depends on whether or not you're paying them an enhanced payment over and above what they would be due statutory. So on here it says right of appeal. So does the employee actually have the right of appeal? Well, there's no legal right to be able to appeal the decision. However, it is good practice to provide the employee with the right of appeal. And also it provides you with an opportunity to, in effect, find out whether or not the employee was dissatisfied with the outcome, and potentially whether or not they're going to go forward with a claim at the Employment Tribunal. It also provides you with an opportunity to go back and rectify any issues there may have been actually during the redundancy process. So it may be that you have to go back and look at all the scoring again, and to make sure that it's fair. Now that brings us to the end of the webinar, and I would like to thank you for listening to our webinar today. And I see that we have had a number of questions, so we will deal with as many as we can within the time frame that we have. And David, I see there's a question there which says, if I've started a capability process with my employee, can I make that employee redundant?
Very good question. And that sounds like the kind of case that you've got to be careful about, because clearly, as we said at the beginning, the burden of proof is on the employer to show that they had a fair reason to dismiss, and they're relying on redundancy. So if they've already, there's been some performance issues and that's been discussed, and that could be problematic. Basically, the employer is going to have to make sure that they've got a sound case for redundancy, and they make that clear to the employee, and they can demonstrate that. Got a question for you, Nicola. What if we don't have, if we're a small company and we don't have two managers to do the scoring?
Well, as I said, ideally, you should have two managers undertaking that scoring to show that you've been as fair as possible. However, obviously, I appreciate that there are some companies out there which just wouldn't have those two managers available, and there would only be the one manager. So it would just be the one manager that would be able to do that scoring. So what you need to do is just to make sure that the criteria is objective as possible. And as I said, if you've got personnel records, such as appraisals, then you are looking back at those when you are doing the scoring. David, I see there's another question there. I have 3 secretaries in the company, all working within different departments. Now I want to make a secretary redundant from the sales department, as that's the department that's making a loss. Now, do I need to place all of them in a selection pool?
Almost certainly, yes. Unless you could show that what they did, even though they had the title secretary, they did quite different roles, then you might be able to make a case for saying that you didn't need to involve them all in the selection pool. But assuming they're all doing pretty much the same work, then you'd need to probably have them together in a selection group if it was going to be fair. I think we've got time for one more question. So somebody's asked about the slides. We will email the slides through. But last question for you, Nicola, and there's 2 that are similar. One is, what do we do about health considerations? And the other one is, we've got an employee who's had a lot of time off due to obesity, do we disregard that when we do the scoring on the attendance? So they're sort of similar questions. Can you tackle that?
Right, okay, well, you need to consider whether the health issues are potentially caused by a disability. So if we look at obesity in itself, that is not a disability. However, that could cause conditions which may be considered to be a disability. And again, with both of those questions, with the health issues as well, it depends what those health issues are, and could they be related to a disability. Now, if they could, you would certainly be in a safer position to just disregard those absences and not take them into consideration when you are doing the scoring.
Okay, thank you, Nicola. We've overrun slightly, so I think we're going to draw it to a close. So thank you, everybody, for joining us. Join us for the next one, and we'll leave it there. Good morning.
Thank you.